North Carolina passed laws that made it so much more difficult for Black Americans to vote that a federal court of appeals mentioned that it, quote, targeted African Americans with almost surgical precision. Texas also has a long history of racial discrimination in voting and was therefore once also covered by the Voting Rights Act. But after Section 5 was gutted in Shelby, Texas quickly returned to some of its discriminatory voting practices. Of the more than 1,600 polling places closed after the court's decision, at least 750 were in Texas. Texas also restricted interpretation assistance for English limited voters. And this year, the governor of Texas issued an order that limited the number of drop boxes for completed mail-in ballots to just 1 per county. Before the order, Harris County, Texas, which includes Houston, and had 11 ballot drop-off locations in a county of over 4 million residents and a county that covers about 2,000 square miles. Many people would say that it is just common sense that going from 11 drop boxes to what it did, which is to reduce it to 1 single drop box, has made it more difficult for people to vote. The Supreme Court has long recognized that our right to vote is fundamental because it preserves and protects all other rights. No right is more precious in our democracy. Any nominee to the Supreme Court must understand the effect and the fact of ongoing efforts to discriminate against Black Americans, Latino Americans, Native Americans, students, and other communities of color. Since the Supreme Court's decision in Shelby, at least 23 states have passed restrictive voting laws and have attempted to also close polling places, stop early voting, and take people's names off the voter rolls that should not have been removed. So Judge Barrett, in Shelby County, Chief Justice Roberts wrote, voting, and quote, voting discrimination still exists. No one doubts that. And my question to you is, do you agree with Justice Roberts' statement?
Senator Harris, I want to just make sure that I understand, that my understanding of what remains of the Voting Rights Act, what happened in Shelby County, is consistent with what you're describing. The pre-clearance requirement, as I understand Shelby County, remains in place, and what the Supreme Court held unconstitutional was the coverage formula. So some states, which in 1965 had a history of discrimination, had to get pre-clearance whenever they changed anything having to do with their voting procedures, and other states didn't. And I think Shelby County said that Congress can still pass a new coverage formula now, articulating the criteria for jurisdictions that are discriminating and requiring pre-clearance.
Judge Barrett, my question, however, is do you agree with Chief Justice Roberts, who said voting discrimination still exists? No one doubts that. Do you agree with that statement?
Senator Harris, I will not comment on what any justice said in opinion, whether an opinion is right or wrong, or endorse that proposition.
Well, I'm asking you, do you call it a proposition or a fact? Are you saying you do not agree with a fact?
Senator, I'm not going to make a comment. I'm not going to say that I endorse either the majority or the dissent in the case of Shelby County.
Well, I just want to understand, are you saying that you will, you refuse to dispute a known fact, or that you refuse to agree with a known fact?
Senator, I'm not exactly sure what you're getting at with asking me to endorse the fact or whether any particular practice constitutes voter discrimination. I'm very happy to say that I think racial discrimination still exists in the United States, and I think we've seen evidence of that this summer. But as to engaging,
that voting discrimination exists based on race in America in any form?
Senator Harris, there have been cases. We've talked in this hearing about the Wisconsin case that went up to the court involving voting. I think anything, any opinion that I would express, and I don't mean to signal that I disagree with the statement either. What I mean to say is I'm not going to express an opinion because these are very charged issues. They have been litigated in the courts, and so I will not engage on that question.
During his confirmation hearing in 2005, Chief Justice Roberts was asked about the constitutionality of Section 2, which I think you were referring to earlier, of the Voting Rights Act. He testified, quote, "I have no basis for viewing Section 2 as constitutionally suspect, and I don't." Judge Barrett, do you agree that Section 2 of the Voting Rights Act is constitutional?
I think that Chief Justice Roberts' statement, "I have no basis for viewing it as constitutionally suspect," would be the same as mine. I'm not aware of any constitutional law existing that would create a question about it.
Thank you. As Senator Hirona mentioned yesterday, in a 2018 case before the Supreme Court, a group of workers were denied overtime pay and joined together to file a lawsuit against their employer. The corporation argued that workers didn't have a right to go to court as a group and could only raise disputes in arbitration individually. Unlike a court proceeding, arbitration is private. The process is hidden from the public and generally cannot be reviewed for fairness by a court. And in many cases, people are forced to agree to arbitration if they want to get the job. In 2018, because of a forced arbitration clause, the workers could not go to a court to fight for overtime and instead were forced to fight for overtime pay behind closed doors in a private arbitration. Justice Ginsburg, in dissent, noted that the workers faced, quote, "a Hobson's choice, accept arbitration or on their employer's terms or give up their jobs." She went on to explain that, quote, "employees must have the capacity to act collectively in order to match their employer's clout in setting terms and conditions of employment." She urged the court to consider the, quote, "extreme imbalance," unquote, "of power in our nation's workplaces and avoid further undermining Congress's passage of labor laws to protect workers and place them on equal footing." Do you recognize Justice Ginsburg's point that there is, quote, "extreme imbalance of power between large corporations and individual workers"?
Senator Harris, I'm going to give you the same answer that I gave you with respect to the sentence that you quoted me from Chief Justice Roberts' opinion in Shelby County, that I'm not going to engage in critiquing or embracing portions of opinions, especially opinions that have been recently decided and are contentious from the court.
And, you know, you've been on the bench a short time, but I'm going to just point out that I do believe, and commentators have noted, a pattern that you've had of ruling against workers and in favor of corporations. For example, in Berlocka v. Contact Transportation Services, you ruled against long-haul truckers seeking overtime pay for additional work. In Wallace v. Grubhub Holdings, you ruled against delivery drivers seeking overtime pay, forcing them out of court and into private arbitration. In Harris v. YRC Worldwide, you ruled against 4 black truck drivers who alleged their employer assigned them less desirable routes when compared to their colleagues. And Smith v. Illinois Department of Transportation, you ruled against a black worker who was called a racial slur by his supervisor. And in fact, if you go on, according to an independent analysis of your decisions, Judge, it appears you have sided with business interest over workers and consumers in about 85% of your business-related cases. Moving on, climate change, as many have mentioned, over 9,000 homes and structures have been burned, and Californians have been forced to breathe dangerous smoke. All of this, obviously, during a pandemic which attacks the respiratory system. But rather than work to combat climate change, the Trump administration has rolled back environmental protections and removed the term climate change from government agency websites, including the EPA. In 2007, in Massachusetts versus EPA, the Supreme Court decided by a 5-4 ruling that states could sue the EPA for its failure to combat climate change during the Bush administration. Justice Ginsburg was the crucial fifth vote in that case. Following that ruling, the EPA responded by unequivocally, finding that climate change and its impacts are a danger to the public health and welfare. Justice Barrett, yesterday you said that, quote, you have read things about climate change, but you would not say you have firm views on it, unquote. In response to Senator Blumenthal today, you said, quote, you are not competent to opine on what causes global warming, and that you, quote, don't think your views on global warming or climate change are relevant to the work you do as a judge. I certainly do believe your views are relevant, and I'm very concerned about your statements. Since the Massachusetts v. EPA case, scientific consensus has grown even more and stronger that climate change is real, and it is caused by man-made greenhouse gas pollution, and it poses significant threats to human life. If a case that comes before you would require you to consider scientific evidence, my question is, will you defer to scientists and those with expertise in the relevant issues before rendering a judgment?
If a case comes before me involving environmental regulation, I will certainly apply all applicable law, deferring when the law requires me to. And as I'm sure you know, Senator Harris, the Administrative Procedure Act does require courts to defer to agency fact-finding and to agency regulations when they're supported by substantial evidence. And only,
yes.
So yes, I would apply that law and defer when the law requires me to defer.
And do you accept that COVID-19 is infectious?
I think, yes, I do accept that COVID-19 is infectious, that's something of which I feel like, you know, we could say you take judicial notice of. It's an obvious fact, yes.
Do you accept that smoking causes cancer?
I'm not sure exactly where you're going with this, but, you know, the notice that smoking
it's just
causes...
a question. The question is what it is. You can answer it if you believe yes or no.
Senator Harris, yes, every package of cigarettes warns that smoking causes cancer.
And do you believe that climate change is happening and is threatening the air we breathe and the water we drink?
Senator, again, I was wondering where you were going with that. You have asked me a series of questions that are completely uncontroversial, like whether COVID-19 is infectious, whether smoking causes cancer, and then trying to analogize that to eliciting an opinion on me that is a very contentious matter, opinion from me that is on a very contentious matter of public debate, and I will not do that. I will not express a view on a matter of public policy, especially one that is politically controversial, because that's inconsistent with the judicial role.
Crisis. The Senate should be working day and night to provide economic relief to families and not rushing a Supreme Court confirmation. We are also in the middle of an election. More than 12 million Americans have already voted. The American people want whomever wins this election to fill this seat. My Republican colleagues know that, I believe. This hearing has done nothing to alleviate the concerns raised about why this nominee was chosen and why this is being rushed when the American people deserve to be heard. So again, I would say, let us not pretend that we don't know what consequences rushing this confirmation will have for the American people. There are countless issues at stake, and to be candid, people are very, very scared. They are scared that allowing President Trump to jam this confirmation through would roll back rights for generations, scared about what it means to the future of voting rights, about what it means for civil rights, for workers' rights, for consumer rights, for climate change, and the right to a safe and legal abortion, not to mention access to health care regardless of income or pre-existing conditions. They are also deeply concerned about what this means for our nation's continued pursuit of the timeless principle, equal justice under law. And I share those concerns. Sadly, my Senate Republican colleagues are doing, I believe, great harm with this illegitimate process. And if they are successful, it has the potential to do great damage. And I believe that damage is to the people of our country and to the United States Supreme Court. Thank you, Mr. Chairman.
Thank you, Senator Harris. Senator Kennedy.
Thank you, Mr. Chairman. Judge, let's try to answer some of Senator Harris's accusations. Are you a racist?
I am not a racist, Senator Kennedy.
You're sure?
I'm positive.
Do you support, in all cases, corporations over working people?
I do not, and I think if you look at my record, you will see cases in which I have decided in favor of plaintiffs, not corporations.
Are you against clean air, bright water, and environmental justice?
I am not against any of those things. Those are policies that the Congress has pursued in many statutes, and I think we all reap the benefits of when those statutes work.
Do you support science?
I do, and I help my children with their homework when they're trying to learn it.
You're sure of that?
I am sure I believe in science, and I support science.
Do you support children and prosperity?
I support children, 7 of my own, and then support others. You know, obviously think children are our future, support children, and yes, I support prosperity.
Do you hate little warm puppies?
I do not hate little warm puppies.
Okay, I just want to get all that clear. See, we did that in about 2 minutes.
I think that my daughter Juliet, who's 10, would want me to put in a plug right now to say I do not hate chinchillas, because we don't have a puppy in the Barrett house, but we do have a very fluffy chinchilla, and so I don't hate chinchillas either.
Duly noted. Look, Senator Harris is my friend, and I get it. She's running for vice president, but I want to address these voting rights allegations. Senator Harris has implied that some states are pristine and other states aren't in terms of discriminating against people on the basis of gender or race or ethnicity. We disagree. She thinks America is systemically racist. I don't. I think our history is the best evidence of that. I don't think we're a racist country. I think we're a country that has some racists in it. You know, I'm very proud of the fact that our country has gone from, in 150 years, which in the grand scheme of life, death, and the resurrection is the blink of an eye, we've gone from institutionalized slavery to an African-American president. We've passed, I'll miss some of these dates, but we've passed civil rights laws in, I think, 1869, 1871, 1957, 1961, 1965, 1990, 1991. I'm pretty proud of that. But let me get back to my point. My good friend, Senator Harris, and she is my friend. I have an enormous amount of respect for Kamala. She suggested that some states are wicked and other states are pristine. And I would gently remind her that California, a state I love, I love visiting California. You got to keep moving because they'll tax you if you stand still. But I love California. But California has a deep history of discrimination against Asian Americans. California has a deep history of discrimination against Hispanics. And I'm not saying they're true, this is true, but there have been serious allegations made against Senator Harris that as Attorney General of the wonderful state of California, that she participated in racial disparities in prosecution. Now, let me jump subjects again. We've talked about precedent and stare decisis and why it's important. We need to have stability. People need to be able to rely on the law. But you're not suggesting that the United States Supreme Court never has, nor should it ever, reverse precedent if they think they got it wrong, are you?
No, the Supreme Court has always acknowledged that there are circumstances in which it must be able to reverse precedent.
And you mentioned reliance interests. How many Americans have relied on a particular decision by the United States Supreme Court as a factor in deciding whether to overturn that precedent?
Yes.
Reliance interests are not dispositive, are they?
Reliance interests are not dispositive. For example, in Brown versus the Board of Education, I mean, clearly the South had an entire system of segregated schooling built up, and so they had relied on Plessy versus Ferguson, but reliance interests were not dispositive there because you do.
There were a lot of reliance interests on Plessy v. Ferguson, weren't there?
There were. So I think Brown illustrates that reliance interests are not dispositive. You have to look at all the factors in the stare decisis test.
Okay. Yesterday, another friend, Senator Booker, Rhodes Scholar, hell of a tight end too, Stanford. He asked you if you, I wrote it down, empathize with people struggling to pay for health care. And of course, you appropriately said yes. I mean, we all do. Under our Madisonian system of separation of powers and checks and balances, which branch of government is supposed to address the struggle that many Americans have to afford health care? Congress or the United States Supreme Court?
Congress, Senator Kennedy.
Let's talk just a second about state constitutions. I know you know this, but we forget sometimes that state constitutions preceded our federal constitution. Am I right? Mm-hmm. And in fact, there are parts of our federal constitution that were copied from state constitution. Mm-hmm. Having said that, there are a lot of provisions that are similar. For example, we know we have a Fourth Amendment in the federal Constitution. Many states have their own version of the Fourth Amendment.
Yes.
What happens when a state Supreme Court construes its Fourth Amendment differently than the United States Supreme Court construes the federal Fourth Amendment?
So the state is free to construe its Fourth Amendment differently as a matter of state law, but of course, the federal Constitution also applies to the states through the Supremacy Clause. So a state isn't free to violate the Fourth Amendment. But one thing states often do, which I'm sure you know because of your interest in state constitutions, and we talked about the Louisiana Constitution yesterday, is that many states interpret their versions of the Fourth Amendment or other provisions to be even more protective of rights than is the United States Constitution.
So the federal Constitution sets a floor.
But not a ceiling.
So if Louisiana wants to construe its Fourth Amendment as not having any exceptions to the warrant requirement, we could do that.
States are free. They're free to fashion their policies as they want within the limits of the federal Constitution. And so the contours of the federal Fourth Amendment would not themselves prohibit Louisiana from doing that.
Yeah, why does that make sense to you?
Well, that's federalism. So my friend Judge Jeff Sutton on the Sixth Circuit has written a book called 51 Imperfect Solutions. And his point is that, we have all these laboratories of democracy, as they're called, the states, and it's federalism. Different states have different preferences. Their electorates can make different decisions in Louisiana than in Indiana than in California. And so if some states want to have greater protections, and many do, we allow those differences to flourish within the limits of the common denominator that we have, which is the United States Constitution.
And that's just respect for the states.
That is.
Okay. The federal Constitution has a state action requirement, am I right?
It does.
Okay. Would a state be free to not have a state action requirement?
I am not aware of any principle that would prevent a state from, in a statute or a constitutional provision. I mean, states can be the master of their own constitutions, right?
And what do I mean when I'm talking about state action?
State action requirement, so the only constitutional provision, I think, in our Constitution that applies directly to individuals is the 13th Amendment, which prohibits slavery. The 14th Amendment, which is the context in which the state action requirement has been explored in Supreme Court case law in the civil rights cases, means that the equal protection guarantee, or even all the Bill of Rights that are incorporated through it, like the First Amendment, only apply to the government. So when I'm teaching this to my con law students, what I tell them is that I can tell my kids at the dinner table, the First Amendment doesn't apply here, because they'll often say, like, hey, what about my freedom of speech? And I'll say, you don't have any, because in my house it is the law of Amy. So, but public universities, are different than private universities in that regard, because the First Amendment applies to government-run institutions, but not to private universities.
Yeah. I don't know what the law is right now, but I think there was a case, maybe it's been overruled, but the California Supreme Court, based on its constitutional history, has ruled that the First Amendment in the California Constitution, or the First Amendment version, has no state action requirement. It doesn't just protect you against government, it protects you against everybody. It's just
I didn't know that.
Yeah, some interesting litigation. I read somewhere that you are an admirer of Kate Chopin.
Oh, yeah.
Who is? Tell us who she was and why you admire her.
Well, when I was in college, back in my English major days.
She's Louisiana, wasn't Louisiana,
That
right?
is,
Yeah.
that's right. And she wrote a book focused on Louisiana and a woman who comes to Louisiana from, now I can't remember what part of the South she was from, and talked about her becoming accustomed to New Orleans and its particular culture. And I very much appreciated that because, it, especially, as a New Orleanian, I thought it was an insightful look into what the history of New Orleans is like. And my family, my great-great-grandparents came to New Orleans from France, and my family's been in New Orleans for generations, and so its history is important to me.
Ms. Chopin had a very feminist point of view, too, did she not?
She did. So the awakening.
Sort of before her time, yeah.
She did.
Two more. Tell me what the legal authority is, if you know, for a universal injunction. We got about 600 federal judges, federal district court judges. I could be off by a few. And they not only have limited jurisdiction, but they have limited venue, if you will. They hear cases in a certain geographical area. How can one federal district court judge in a limited venue enjoin a congressional statute or a presidential executive order for the entire United States, continental and otherwise?
Well, that is a disputed issue of law that's in litigation, and the court, it's been on the court's docket, the authority of district courts to issue nationwide injunctions. So that would, take me down the path of opining on a case that, could wind up in litigation in front of me.
Okay. I got one last question.
Hope it's an easy one.
It is. It's a sincere question. I'm genuinely curious. Who does the laundry in your house?
We increasingly have been trying to get our children to take responsibility for their own, but those efforts are not always successful. So we run a lot of loads of laundry.
Well, you're very impressive, Judge.
Thank you, Senator.
I yield back, Mr. Chairman.
Thank you very much, Senator Kennedy. Senator Blackburn.
Thank you, Mr. Chairman, and thank you for your endurance today. We appreciate it. I have a couple of things for the record. A letter in support of Judge Barrett from the Republican National Lawyers Association, and then also the op-ed that was in the Washington Post September 25th. It's by John Garvey. I taught and worked with Amy Coney Barrett. Here's what people get wrong about her faith. It is, he is president of the Catholic University of America, and it is in support of her nomination and confirmation.
Without objection, while I have it on my mind, thank you for reminding me. I have a letter from Reverend Franklin Graham supporting your nomination, and Jack Goldsmith, a professor of law from Harvard. I'll introduce those two. Thank you.
Mr. Chairman,
Yes, sir.
I asked to include in the record letters in opposition to the nomination from 50 organizations on immigration, A Better Balance, and 88 other organizations support rights of working families, 320 law professors specializing in health law, disability law, and constitutional law, and the Alliance for Justice Lawyers for Good Government of over 6,200 attorneys.
Without objection, Senator Blackburn.
Thank you, Mr. Chairman. Just a couple of things, again, tying up some loose ends before we let you get on your way. Senator Harris mentioned, as did others, that they would like to see us working on COVID relief. Again, I want to remind my colleagues they had the opportunity to vote on this a couple of weeks back, and if Senator Harris chooses to come in next week, she's going to have the opportunity to vote on COVID relief once again. She mentioned the California fires, and in relation to her comments to you about climate change, I would just remind my friend Senator Harris that it is pointed out regularly that these fires occur every year. Some years are more difficult than others, and we just grieve the loss of property and life and livelihood for Californians, but we also note that California state officials have not been successful in getting their forest management plans under control. So we would note those things. Judge Barrett, I think it is no secret that the Democrats are trying to drum up a lot of hysteria about you to spread some fear and misinformation. And much of this is centered on Americans' health care. And here's the reality. Our friends across the dais here are wanting to do a single-payer government-run system. And they fear that a constitutional court would block them from taking control of health care, from taking private health insurance away from 153 million Americans. And they have centered this entire attack talking about the ACA or Obamacare. And as I said yesterday, there are 8.3 million Americans in the Obamacare program. And in addition to the 153 million that have private health insurance, there are 57 million senior Americans that have been paying in to Medicare all their working life. And they would lose that with a government-run single-payer system. And I feel like that our friends across the dais have really tried to paint you as a monster with an agenda. And I have appreciated that you have said repeatedly, I have no agenda. And we know that, as I said, they've got their goals. They have their goal on healthcare, for socialized medicine, for ending the doctor-patient relationship, for making a bureaucrat-patient relationship. They've even said pre-existing condition coverage would go away, which is not true. That is widely supported by Republicans and Democrats. It actually originated with Democrats in the Senate and Republicans in the House. And they've also said older children would lose their health care. Not true. Again, that has bipartisan support. But I think what has struck me the most through some of these comments is that they say that you have to have diversity in order to have equality. But what I have watched them do through this entire process of questions and talking with you in opening statements is they have chosen intellectual isolation as opposed to having diversity bring a different perspective. And to me, that is really very sad. And to my friends across the aisle, I would say that the American people are no more afraid of the ideas of a Catholic woman than they are of the words splattered on a protest poster being held by a liberal woman. They don't fear that. I've also found a few things said about you to be unnecessarily condescending, and I regret that. I know that some think they can verbally pound you into submission to a more leftist agenda. I found it very curious that one of our colleagues even said that they fear you would usher in conservative activism on the courts. But one of the things that those of us on our side of the aisle continue to say, we don't want activist judges from either the left or the right. So my colleagues should be comforted in the fact we don't want judicial activism, period, end of sentence. We want jurists that are going to call balls and strikes, that are constitutionalists, textualists, originalists. That is important to us. And some of my colleagues on the other side of the dais have seemed to be quite amazed that you could balance career and family. And I would think that they would choose to praise you for finding a way to do the work that you feel called to do and balancing it all. Maybe they should be curious about how you meet the demands of family and work and friends and church and all the different balls. I know when my kids were small, I felt like I was juggling balls coming and going. And now that I have grandkids, I feel about that same way sometime. And they have been almost, unfortunately, have this tone of condescension around that there would be a woman from the political right who would try to have it all. And as I tell my daughter regularly, you can have it all, just not at the same time. Things have to get spaced out, and you take these tasks as they come. And we see that what they have done is to continue to project their thoughts, their desires, their concerns onto the American people, using words about malicious, fear, terrified, scared. The American people are not afraid of you. They wanted to lecture you. I found it condescending, the way they accused you of not understanding recusal rules. I appreciated that you were quite quite able to defend yourself on that point. When my team and I were talking about this, I told them, yesterday I sat here, now Senator Kennedy talked to you about a Louisiana author. I thought about a Nashville songwriter. In Nashville, we say everything begins with a song, begins and ends with a song. Now, one of my old neighbors, the late, great Eddie Arnold, had this song that was a great song. It was a love song, but the title of that is very applicable here. The song was called You Don't Know Me. And in one of our visits one day, I asked him about the story behind the song, which many times is more interesting than the lyrics themselves. And he said the story behind the song, what he had shared with the songwriter who wrote it, was that many times we miss the richness of a relationship because we don't stop and take the time to get to know someone. And that, I think, is what my colleagues did to you. They made this all about the Affordable Care Act. They made it all about issues that they wanted to talk about because we are 20 days away from an election. And what they did was, in the projection that they did, projecting their thoughts onto the American people, they projected stereotypes onto you. Those stereotypes are what they think about us as women on the political right. And they enjoy being able to mock and to ridicule and to diminish and to demean. To them, it is political sport. It is the politics of personal destruction, and it is wrong. It is wrong. I think one of the things that really gets them is this. You don't fit into their elitist format. You're a girl from the South, from New Orleans. You went to school at Rhodes in Memphis. I don't know if my colleagues have ever been to Memphis or ever been to Rhodes, which is a wonderful school. But you don't fit into their Harvard, Ivy League type group. You're not a part of the clique or the club. So you left Rhodes, you go to Notre Dame, and people look at you and say, exceptional. She is doing great work. We're going to help her to get to a different spot in her career. And they did. They opened doors. You came to D.C. You clerked. But, Judge, you messed up. You went back to Notre Dame. And you chose to teach and to have a family and to have friends and a sense of community. Right there in the middle of the heartland. And see, now they don't want to admit you got where you got. You earned it. Nobody gave you a shortcut. You earned it. And that is why we are so honored to support you. Thank you.
I'd like to associate myself with those comments, Senator Blackburn. I'm going to tell you about where I grew up. I don't know why. It just seems to be a good way to end this thing. It's got nothing to do with anything. But I grew up in a small town called Central South Carolina. the first in my family to go to college. My dad owned a bar, a pool room, and a liquor store. And my mom ran the bar, and my dad ran the liquor store, and when I was old enough, I ran the pool room. This is why I think I'm a good senator. It's good training for this job. But I remember, speaking about country music, we had a piccolo. You know what a piccolo is, Judge?
I don't know what a piccolo is.
Well, you're too young. Piccolo is something you put money in to listen to the song. And the one song that I remember to my dying day, talk about country music titles, was "My Wife Ran Off with My Best Friend and I Miss Him." So this is a wonderful country. And I just want to say to my Democratic colleagues, I have lost sleep over this hearing. I did not know how it would go. There's a lot of tension. 2020 is the year that is unbelievable in every fashion. You've asked challenging questions of the nominee. You've asked probing questions of the nominee. And at times, you've done some of the things that Senator Blackburn talked about, in my view. But thank you on behalf of the country for allowing us to get through this hearing in a fashion that I think is befitting of the Senate. To my Republican colleagues, thank you for being patient. But this is not about us, this is about you, Judge. I will end where we began. The hope was not to really change anybody's mind. I don't think that's possible in today's environment, and I say that accepting 2020 for what it is. But I'm hoping that people who did not know you better. I'm hoping that young women who are conservative see hope in you, what Senator Blackburn said. I hope people who've listened find your disposition reassuring. You're one of the most amazing human beings I've ever met in my life. And that's saying a lot because I've got to meet a lot of incredible people as a senator and otherwise, serving in the Air Force. Your knowledge of law is just unbelievable, deep and wide. Your judicial philosophy, I think, is very mainstream. You're exactly who a Republican would be looking at picking, not so much a Democrat. And that's not a slam on you because elections have consequences. And to my good friend, Senator Whitehouse, I want to reform the system. It needs to be reformed. But nobody had to spend 15 cents to tell me that you're qualified. I figured that out on my own. I followed your career from afar. And this is the first time I've really had a chance to interact with you. And all I can say is that I've seen a lot of people come and go. We've had some of the most talented people in this country sit where you're sitting, and you've acquitted yourself well. You have much to be proud of. Your children have much to be proud of in their mother. Your husband has much to be proud of in his wife. You have much to be proud of in terms of how you served your country thus far. And with Amy Barrett, the best is yet to come. So, in another time, in another place, you would get everybody's vote. It's not about you. It's about us. Somehow we have lost our way. There's no use blaming one side versus the other. It always seems to be that our people get treated pretty harshly. I voted for Sotomayor and Kagan because I saw in them the qualities that a Democratic president would be looking for and the character, the integrity that the public would appreciate and would be fitting of the job. Elections do have consequences. This vacancy came about through a tragic demise of one of the greatest women of any time. She did things that no other woman was able to do, and through her actions paved the way for women to achieve their goals. She has a different philosophy than you do judicially. That is okay. I hope it's okay that you can be pro-life and adhere to your faith and still be considered by your fellow citizens worthy of this job. I think you have met every test that any reasonable person could impose in terms of qualifications. I think you've made every test in terms of disposition and character that the public could hope for in terms of having somebody sit at the table at the Supreme Court. You will be confirmed, God willing. You will have my full support. I see in you someone who's not only highly qualified to be in the court in every way possible, but somebody that has broken new ground in a positive way for the country. So what we will be doing now is go in closed session. The FBI evaluation will be presented to the committee. That's standard practice for every nominee. We will meet again here just in, where's the room? Dirksen G50. You will be with us. We do this for every nominee, going back to Chairman Biden. And it is over. The hearing part is over. You can have 2 glasses of wine tonight if you like.
Mr. Chairman,
Yes.
I'll defer to Senator Durbin if he wants to go first.
Yes, I would just like to finish my thought, then we'll defer to Senator Durbin. The hearing part is over. You acquitted yourself well, but the journey you're about to take is going to be challenging, it's going to be rewarding, and may God bless you in this endeavor. Senator Durbin.
Mr. Chairman, on behalf of the Democratic side, I won't speak for Senator Blumenthal. He can